They've just decided that you can quietly close all these things and redirect the efforts of the DOJ to punishing political adversaries and spending taxpayer money to do it. Welcome to Signal Fire. Hi, everyone. Welcome to another episode of Signal Fire. I am Lisa Senecal.
And I'm John Zieger.
This is what you're getting today.
This is what you're getting. Just us chickens again.
Yeah.
We thought it's been a light news week. We'll talk about the weather.
Not much.
What we're doing over the weekend.
Getting the Voting Rights Act. Just no big things happening. And that is going to be, gutting the Voting Rights Act is not going to be the theme of this episode, but we do want to talk about the courts. And there are a number of things happening in the courts this week and more sort of long-term changes that have been going on.
Yeah, it's been an interesting week in law, legal filings, court decisions. I think we are seeing in general across almost every part of our kind of national politics that it's the courts that have become the kind of battlefield of last resort for a bunch of things. So it's a kind of an interesting moment. And maybe let's start out with an Instagram post. 8647.
We're talking about James Comey again. James Comey has now been indicted again, and this time it is the great Seashell conspiracy, which is writing something out on a beach in seashells is the weirdest way to apparently try to take out a hit on somebody. But this is what the DOJ is alleging because James Comey posted a picture that said 8647 spelled out in seashells on a beach to Instagram.
He did this about a year ago. I don't know the exact date. Maybe we can Google it real quickly. But he posted a thing which he says he found on the beach. So he's not even the writer of this thing. He is merely a person who took a picture of seashells on some beach in North Carolina that says 8647. The allegation is that people that would have been understood to be a call to assassination, to murder. Somebody who grew up when you would see a lot of old timey movies on reruns, the idea of 86ing something, or what MASH or whatever was, it was like a phrase that I heard, but didn't use. I guess it comes from restaurant jargon. When you take something off the menu, you 86 it.
Didn't know that.
And so that's that is at least what the scuttlebutt on the internet seems to be.
That's the violent origin of the
violent origin. You remove it from the menu. And the allegation is that the posting of this photograph was a call to violence against the president, and the FBI director Cash Patel got up and gave a serious press conference about how this is what the FBI. This is a serious investigation. It's just anyway. It's bonkers on its face, and the Justice Department is going to lose this case, and I wonder why you think they brought it. I don't what's your take on? It's so ridiculous. They're going to lose the case.
They're going to lose the case just like they lost the last case, and the judge in the first hearing that they had on this decision was made whether or not he was going to be held or if he was going to be released on bail or if he was just going to be released. The judge's attitude, I think I'll paraphrase, was he wasn't a threat the last time he was out without bail, and he's not a threat this time. The court has to take it somewhat seriously because it's before them and they don't just get to, at some point, I suspect they are going to just throw this out because it is ridiculous. But in the meantime, this is interfering with this person's life, costing a lot of money, costing a lot of time, and also sending really scary messages to anybody else who thinks about crossing this administration and Donald Trump in particular, because I mentioned this to you earlier, John, I've never been on the receiving end of any legal action launched by the Department of Justice, but it's a pretty big deal. And that the weight of the federal legal department is it's not exactly an even playing field that you're on.
I mean, it's maybe important to say a little bit more about that, because I have been on, not as an individual, thankfully, but as a lawyer in a company, as a general counsel of a company, sometimes you get filings from the Department of Justice. Maybe they're about you, maybe they're about one of your customers, and those rise to the top of the heap. The government, they are not things that you delay. They are not things that you give to a junior person. They're always serious, and they're serious for a bunch of reasons. One of the things to keep in mind is that when the Department of Justice is investigating you or charges you, now, and of course, keep in mind, they've charged, they've indicted, they took this charge to a grand jury, and as the saying kind of famously go, a grand jury will indict a ham sandwich, right? I mean, you basically just have a prosecutor in there making that case without any kind of opposition, without really rules of evidence or anything else. And so all you have to do is kind of, demonstrate that there is some reasonable belief that a crime is committed. I don't remember the exact words of the standard, but that's the gist of it. Even without the indictment, the Department of Justice can do all kinds of things, right? They can subpoena your records. They can send a subpoena to your bank, to your phone company. They can get your text messages. They can often do all kinds of they can get your search records, and they can do all kinds of things. In some cases, they're going to need a warrant for that, but they can often obtain that. But often they can do it just with a subpoena, meaning they don't need to go to it. They never have to go in front of a judge to get it. They can just send a letter from the Department of Justice. It's very, very powerful, and they can start fishing around. And in a case like this, once they start asking questions, they start maybe they get you for some kind. They ask you some question that you answer in a technically wrong way because you don't want to go down some avenue or whatever. Right now, suddenly they're creating surface area that they can potentially threaten other kinds of actions. Of course, if they're willing to bring forth a case for something as ridiculous as an Instagram picture of seashells on a beach, what misstatement? You said you were there on Tuesday. You were really there on Wednesday, right? What misstatement is adequate, right? So it is meant to be threatening, and it's justifiably threatening because they have tremendous. Most people who sue you do not have the power to deprive you of your liberty, but the Department of Justice does, and it's incredibly powerful.
Super scary. It's also really infuriating because it takes money. These are taxpayer dollars that are being spent on these ridiculous pursuits as a means of political retribution, and it also means that whatever the DOJ is investigating and pursuing, they're not putting time into something else, and they have dropped a huge amount of human trafficking cases that they were trying to make, investigations that they were doing. I mean, the stuff that this administration has said that they care so very much about, and they've just decided that you can quietly close all these things and redirect the efforts of the DOJ to punishing political adversaries and spending taxpayer money to do it.
What are we not prosecuting? We are not prosecuting virtually any white collar crime in this country anymore.
There's a good reason for that.
Those offices are deprived of almost all of their resources. We are not prosecuting securities fraud, garden variety fraud. We're not prosecuting environmental crimes. in this country anymore. It is open season on pollution and violation of the Endangered Species Act and the Clean Water Act and the Clean Air Act. That stuff is not being prosecuted anymore. We are not prosecuting civil rights violations anymore. Those offices have been deprived of virtually all of their resources.
Including all the people who've been fired, so that the people who now run those departments are, you can pretty much take any of these categories, and the person who's now in charge is on the absolute opposite wrong side of whatever it is they're supposed to be doing.
Yeah, our civil rights prosecutions are of allegations of anti-white discrimination. Right. That's what we're doing now. We're not prosecuting, as you say, child endangerment, these, human trafficking, modern slavery, any of these things. What we're prosecuting is a 70-year-old man who is or whatever I'm just kidding, thereabouts. I don't know. James Comey, I didn't age you, but thereabouts. Who was a career civil servant and the head of the FBI for posting photographs of seashells, which, by the way, James Comey could have posted. I hope the president dies. He could have posted those words if he had wanted to. Because we have a thing that people may be familiar with, which is the First Amendment. You are allowed to do that. Now, it might be gross. It might be impolitic. We may not like it. It might remind you of something that the president of the United States posted, that he was glad that Robert Mueller was dead. Another FBI director, while we're talking about FBI directors. But it is not illegal under any definition of our laws, and certainly is going to be thrown out of court. And this is just kind of a flagrant abuse. The courts will stop it for sure, but that doesn't mean it isn't going to be painful in the meantime. So I think part of what makes this so particularly ridiculous, right? It seems to be a kind of performance by Todd Blanche, the new acting attorney general, to essentially say, there's nothing I won't do for you to keep this job, Donald Trump. And a kind of related thing this week, I don't know, of course, we had this, potential assassination attempt or shooting at the Hilton in Washington around the Correspondents Association dinner, which, by the way, just as an aside, is like way overblown. This is what happens when the media is at the center of the story, is they just assume the story is the biggest thing. Anyway, it's a big deal, but it just strikes me as maybe it's a little bit bigger, a little more was made out of it than, since he never really even got it within a floor of the president, but whatever. Yeah,
and now we've learned that he likely never fired
a weapon. Yeah,
any of his weapons.
Yeah. So, right. Shots were fired, but it was the Secret Service, the Keystone cops shooting one another. Anyway. But immediately the next day, the Justice Department files a motion in the case around the ballroom, where the ballroom has temporarily been enjoined, saying, it's just a totally ridiculous. It's actually kind of funny. Maybe we can post a link to it. It reads like a Truth Social post from Donald Trump that the Landmark Preservation Agency is a fake, all caps, fake. It's just, again, and Todd Blanche is the one who signed that just kind of insane off the hook filing, and I think these are all just sort of performances to demonstrate he really is going to do whatever the president wants. There is no independence here. This is the president's personal lawyer.
He seems a little more serious and a little more reasonable than Pam Bondi did, who came off as sort of a melodramatic pretend lawyer, because she kind of is a melodramatic pretend lawyer. And Todd Blanche, that sort of patina of being reasonable, I think makes him more dangerous than Bondi was, because he can do outrageous things and it doesn't seem quite so outrageous.
No, totally. I mean, I do think it's kind of a weird thing in life generally, that a kind of personal affect often has as much to do, with how you're received as actually the substance of anything, right? If you sort of seem kind of reasonable and your tone of voice is not extreme, your word choice is not extreme, you sort of sound the way we expect people who have that role to sound, right? That you get a lot of latitude out of that. But I think he is benefiting from that for sure.
Well, speaking of people who don't sound how people in that role normally sounds, we're talking vaccines and RFK Jr. Again this week because the DOJ
I'll spare you my RFK Jr. impression. Sometimes I do it around the house, but I think I'll spare it. Yeah.
All right, the next company on site, we're definitely getting some surreptitious video of John doing his RFK Jr. impression. So the DOJ is appealing the court's ruling that put the changes to the childhood vaccination schedule on hold. That's on a shelf right now. The current recommendations stand. The members of the vaccine board that RFK Jr. had appointed, that court had described them as uniquely unqualified. Mm-hmm. Most of them had absolutely no background in vaccine research, public health, anything else you might hope.
Have they eaten roadkill though?
Have they dragged a dead bear out of a park?
No, I mean that's it. You gotta know these things.
Oh man, our qualifications for big posts are so very strange now. So they've appealed this ruling to the First Circuit Court of Appeals, which is has a lot of Democratic appointees, or they were appointed by Democrats. The judges are not Democrats or Republicans. So that's going there now, and we'll see what comes of that. My assumption is the ruling's going to be upheld, and then it might go to the Supreme Court. And what happens then?
The Supreme Court? Who knows?
Who the hell knows?
I think, just as a kind of general matter, the amount of deference that the Supreme Court has shown to the executive branch here is extremely high. And the reality is at least two or three of the justices seem to basically figure out what is the position the administration wants, and then how do we back into a rationale for it. And you have depending on your count, somewhere between, I don't know, 2 to 4 justices that are going to do that on any given case, and you maybe have a couple of justices in play, and then you have your liberals who are going to dissent from it. So one would imagine that is sort of likely here, unless the statute, the underlying statute is very clear. And I think that's probably, and I don't know enough about the issues. It remains kind of extraordinary to me. I mean, just sort of separate from the legal side of this, that the administration is spending political capital on this.
Yeah. People don't like this policy. They do not want this vaccine schedule changed. And that's across the political spectrum. This is not popular with Republicans either.
Yeah, it's very weird. It's a niche issue, and I will grant that RFK and the amount of sort of press that this set of issues has gotten, and of course this is all on the back of COVID, that vaccine skepticism has risen dramatically. So the number of people in the country who are skeptical or anti-vax is meaningful now in a way that it wasn't maybe 5 or 10 years ago. That much is true, but it's meaningful in like the low double digits. It's not like, it's not a majority issue. And when you have things like serious measles outbreaks that people people are getting notices from their kids' schools about this and this kind of thing, right? It's like, I don't understand why you would burn political capital on this.
No, because they could quietly let this let this issue die, at least until after the midterms. They could let these attempts to change the vaccine schedule just lay dormant, and not have this be something that candidates are going to be talking about going into the midterm elections. And what the rationale is for fanning those flames and making sure that we keep having stories written about this, and who knows, more congressional hearings. It never seems to go well when RFK Jr. is up there again, having to be in a Senate or House hearing. And Casey Means, another health nominee, Trump's just pulled her nomination, and he's ticking down the list to, I guess, his number 3 choice now, who seems like maybe she's a more reasonable human being who actually has an active medical license, which Casey Means didn't have.
Unlike our last baby surgeon.
Yeah. The political calculation here, it just baffles me.
My guess is it's kind of coalitional, right? I mean, I think this was always the way that RFK Jr. sort of fit into the Trump world, which is Trump's base is sort of white, non-college, evangelical, and adjacent. Like that's his biggest, and obviously he's chipped into men in various segments, including in minority groups, but what RFK Jr. I think gave him was a somewhat different slice. The kind of suburban mom in Marin who, it's just, there's a kind of a different thing there, right? Where it's not your white evangelical. It's probably more, I think it is somewhat more of a the folks who are in the world of health influencers on the internet. And that is, I think that tends to be more women. It's a certain, it's a little bit of a different demographic. And for various reasons, RFK somehow became very popular among that group of people. And I think he genuinely did bring them into the Trump coalition in a way that they were not before, right? These would be people who might have voted for like a Marianne Williamson or something in the past, right?
Yeah.
But somehow,
that horseshoe thing that appeals to far left and far right, and
totally
somehow and
so that's kind of my theory on it. Is like those people are, in some sense, they are more RFK people than they are Trump people, and they are more Maha people than they are MAGA people, and sort of so they are kind of actually additive to the coalition in a way, even though they're not very large. It's not that big of a group. Increasingly, it's not that big of a group to begin with. So
they could have gotten more mileage out of the administration not defending the continued use of, what is it, glyconophosphate? It's
glyphosate.
Yes. So those are the same people that they want to be able to hang on to. The people who don't want Roundup sprayed on the food, the fruits and vegetables we're going to eat, are the same people who have the issues with the existing vaccine schedule. So doesn't make sense to me.
It's deeply
there's
irrational.
A lot of that.
Yeah. But I mean, again, this is where I do think it's like, this is the role of the internet, right? Of creating these sort of cul-de-sacs of people who have visibility into some set of issues, that, you can build these kind of influencer followings around the, I think the psychological term is kind of appeal to occult knowledge, right? This idea that they don't want you to know, this sort of the most powerful marketing thing on the internet. They don't want you to know this thing, right? Which for various reasons pushes some button in human psychology that a lot of people are vulnerable to. And so
every
you
once
end
in a
up
while,
with this,
one of those things come out. Right? Like they didn't want you to know, and it just reinforces the conspiracy.
No, exactly. There's always enough truth in it. So anyway, but yeah, it is deeply weird and bad, and
Yeah.
and it's kind of a throwback. And in throwback land, we have another interesting throwback this week, which is the Supreme Court's decision in this Calais case, basically not fully invalidating Section 2 of the Voting Rights Act of 1965, but effectively making it a dead letter.
Which is something that this court has been working toward for quite a long time. It's been defanging the Voting Rights Act, case after case, Shelby v. Holder, and it just any opportunity to weaken those protections that were put in place. But I know you have a lot of thoughts on this, John, and kind of what it could mean for the future of the court and what it could mean for elections coming up.
It's a pretty big deal. I mean, I think what maybe makes it a little bit less of a big deal immediately is that it was anticipated, right? I mean, the court took this case some time ago, as you say, going back to Shelby versus Holder, where they invalidated Section 5 of the Voting Rights Act, which was the pre-clearance requirement for certain states, the Confederate states, essentially. So we were left with Section 2, and without going into like all of the details, basically it was a test. Essentially, what it did was extend the protections of the 15th Amendment of the Constitution, but sort of codified that and created a kind of statutory mechanism. So that if the effect of various policies was discriminatory, and the bar had to be very high, to be clear, in order to prove this, but that it could be treated as a violation of the Voting Rights Act, and courts could intervene. So it was modest protection even before, and maybe as some kind of measure of this before our conversation, I did a little bit of this, and this is sort of back of the envelope, so don't hold me to all these precise numbers, but I think in America in 2026, in the preceding decades, since the 1960s. It is true that the African American population, the Black population of America, tends to vote overwhelmingly with Democrats. There's at the margins, there's some movement there, but that is true, and it's true. It's true in virtually every state in the country, and has been pretty durable. And so it's kind of interesting just to look at where we were before this decision. So Mississippi is about 38% Black. They have 4 representatives in the House of Representatives, and they have 1 Democrat. So you would expect them to have approaching somewhere between, roughly about approaching a half of that 4. In fact, they only have a quarter, so they're a little underrepresented. That's bad, but it's definitely not the worst. A state like Louisiana, I won't go through all of them, has 6 House seats, and they have 1 Democrat. Now they're a full third Black in that state, and so on. So this is true basically across every one of the southern states: Georgia, Alabama, Mississippi, Louisiana, Florida, South Carolina. So that was before. It is now the case that most of those seats are going to be eliminated as a result of this. And what you saw was all of these southern states have been, which are controlled, again, even though they have very high Black populations relative to the total population. These are states that are dominated by Republicans and by whites in their legislatures. They are the ones who are drawing the maps, and they were prepared for and the only thing that is keeping them from drawing maps that favor Republicans and whites more was the Voting Rights Act. And now that's gone. They anticipated that it would be gone. And so all of these states have been working on backup maps in order to eliminate the majority minority districts that they have. And so it's expected that that Mississippi seat will be gone. So there will be, even with a state with 38% Black population, you will have 0 representatives, Black representatives, and similarly kind of across all of these, right? So maybe the last thing I'll say is just a little bit on what is this about? The Justice Ginsburg in Shelby versus Holder, in the dissent, and that's where they eliminated Section 5, said that basically chastised the court that it was the court basically said, we don't need this anymore because there's the history of discriminate. There's basically, we're over it, right? Yes, there was a historical pattern of discrimination, but we don't have it anymore. And she said, essentially, this is like a person throwing, under an umbrella, throwing the umbrella away because they're not getting wet in a rainstorm, right? Like, it is the mechanism itself that is protecting us from this. Before the Voting Rights Act, after the Civil War, after we had the post-Civil War 13, 14, 15 amendments that eliminated slavery and gave the vote to Black people, we had a very high, I remember this, we had very high, initially very high rates, voting registration rates, and then almost immediately those were stamped out by a complex series of things like poll taxes and literacy tests and all kinds of other grandfathering tests. So literacy tests only applied to certain people. If your grandfather voted, then you didn't have it. But if your grandfather didn't voted, aka people whose grandfathers or grandmothers were slaves, then you had to pass these literacy tests. And as a result, in many cases, very, very low numbers, single digit numbers to 20 to 30% of eligible Blacks were available. We were able to vote. And that was the state of the world until the 1965 Voting Rights Act, which was passed as a result, was finally the conscience of the country was shocked after Selma and Bloody Sunday and the Voting Rights Activists being beaten for just simply, asking for the right to vote. And we finally changed that. And the idea that we are going to go back to a world where you have to prove actual intent to discriminate is insane. And the result of it is going to be disenfranchisement on a wide scale. And it's just hard to know. It's hard to know how you can look at this Supreme Court and view them as anything like neutral arbiters of the facts and the law.
That they put in this ruling that you need to prove not just that the way the congressional district is now carved up, that it is discriminatory. You have to prove that there was intent to make it discriminatory. And we all know, those of us who, have watched lots of lawyer shows on television, intent is incredibly difficult to prove. Like you need to get into someone's mind and prove, or you have to have access to backroom conversations that weren't recorded. Nobody who was in there is going to testify what the intent was. So the bar now is so incredibly high, and who can now bring a case under Section 2 has been very limited, so that it's borderline. Only the Department of Justice can now bring a case. And in this situation that we're currently in with our existing Department of Justice, the likelihood that they're going to bring a case after all of these Black majority districts are wiped out, and the expectation is we are going to have the whitest House of Representatives that we have had since the 1960s. Since the 1950s. This is just going to wipe out a lot of those seats. The legitimacy of this court at this point is, if you are if you can set aside the partisan views that we all carry, it is very hard to see how this court is legitimate in the way that it is, not just in the Voting Rights Act case, but in so many cases now, that they are tying themselves into pretzels, trying to find ways to justify the decisions that they knew they wanted to make before they even heard the arguments.
Yeah, I mean, you maybe know no better example of this than you may have seen. There was some reporting recently. The New York Times got access to a bunch of private disclosures about the what's sometimes called the secret docket or the shadow docket of the Supreme Court. And this is where they will often rule intervening cases, very often without any written opinion, just an order of the court. Unsigned order of the court intervening, and they've been intervening much more frequently, and really doing so overwhelmingly to just prevent accountability for the administration or allow the administration's activity, whether it's something like Doge or other things, allow these activities to go forward in ways that become practically unremediable. Even as the litigation in theory plays out, they have prevented any kind of an injunction or other things. Like, this is I'm a little obsessed with this topic, and I know it's a kind of controversial one. I think that if you look at where we are in 2026, and I arguably for somewhat longer than that, the last decade at least, the Supreme Court is a kind of a neutral arbiter of facts as a standalone branch that had legitimacy apart from partisan loyalty, apart from loyalty to the president. I don't think that thing exists anymore. And if we do not reform the Supreme Court, no other reform is possible. This to me is the most important thing for people to recognize. I think it was a great mistake of the Biden administration not to take this more seriously. They basically punted it off to a blue ribbon commission in the way that you do when you don't want to deal with hard problems. And they made no attempts at Supreme Court reform, really of any kind. And so, you can think of that at multiple levels. The most obvious is just ethics reform. The Supreme Court, Clarence Thomas has gotten, millions of dollars in gifts that he's not reported until he was shamed into reporting them by, journalism many years after the fact. But extraordinary corruption. It's hard to call it anything other than that, right? You took money from people who had interests before the court, and you did not disclose it. I don't know. I mean, were you required to say, I am ruling in this way for you, my friend? Like that? Clearly not, right? Like but the Supreme Court is unbound by that. They don't have any kind of ethical provision. So that's kind of it seems to me the most obvious thing to do. More important is I think one of the crazy things about our political system is we have made, because these are lifetime appointments, and they're required to be lifetime appointments under the Constitution. Every presidential election becomes a kind of, death struggle for control of the Supreme Court. And that has warped our politics in a way that I think is good for no one, and results in people putting on partisans, I think increasingly sort of younger and younger partisans in order to maximize the and so you get, an Amy Coney Barrett in her 40s, on the court, because they're going to get probably a good 35, 40 years of service out of this one. Right. And that was John Roberts is sort of an earlier example of this. It seems clear to me that we need to figure out some way to do this. I think the most obvious thing to do is to add to the number of justices on the Supreme Court. We have 9 justices right now, and people will remember from history class, Roosevelt's court packing plan and all of the controversy surrounding that. And it will be controversial, but it is Congress under our system of government. It's Congress who sets the number of seats on the Supreme Court, and Congress can pass a law with a bare majority. You just need 50, 50 plus 1, whatever, or, if as long as filibuster doesn't prevent it. And that would go a long way. The most obvious thing for me there is just go from 9, which was the number of circuit courts of appeals that we had at the time. So we had 1 justice per circuit court of appeals when that was done in I think it was the 1860s, if memory serves. to go to 13. We have 13 courts of appeals now, so go to that. Add 4 justices. That would seem pretty reasonable to me. You can also there's some other interesting proposals. You obviously, a justice serves for life, but that doesn't mean they can't be rotated down to the circuits. You could rotate justices in and out of the circuits.
This wasn't something that I understood until you and I talked about this earlier, that the lifetime appointment is only a lifetime appointment to the federal bench, but not the particular role. So you could be in the circuit court, you could be a Supreme Court justice. That they could move around. These don't have to be lifetime appointments to the Supreme Court.
You could. I am fairly sure, and I've read some scholarship on this. I mean, I think it's a debatable point. The Article 3 contemplates a Supreme Court and what it calls inferior courts, but basically everyone is appointed as a judge under Article 3. There's the individual justices of the Supreme Court are not enumerated in Article 3. So you can imagine very easily, like the proposal would be that essentially the Supreme Court is staffed by a rotation of circuit court judges, and all of those are Article 3 judges. They all serve for life. They're, or during good behavior, as Article 3 says. But they aren't hearing cases at the Supreme Court during all that time. Sometimes they hear cases in the Second Circuit, and sometimes they come up for a year and they hear cases in other. And this is a system that other countries have, so it's not a totally unique thing. But that I think is a realistic solution that somebody could put forward. It also has the nice benefit of being not obviously a kind of random rotation of judges where you always have 9 or 13 or whatever judges hearing the case. Maybe every year you're rotating them through, or even more frequently. There are certainly examples of courts around the world where they rotate justices between circuits more frequently. That nobody can look at that and know immediately that it leans Republican or it leans Democrat. It's just right. A different system, with less of a kind of ability to count noses of these particular 9 people who have been there forever, and we know exactly what their interests are. We know exactly what their partisan leanings are. That's where we are, and it seems to me that's very bad for our system. And these kind of proposals would fundamentally change that.
Yeah, and the whole purpose of having these lifetime appointments was supposed to be that judges didn't have to be partisan, because they weren't going to have to run for election. They weren't going to have to raise money. They weren't going to face voters. That they truly could be neutral arbiters of the law. And clearly that broke down before Trump. But it's broken down even more since then. Damn Mitch McConnell's cold black heart that he has done what he's done to this court. It should be a stain on his legacy forever, that he has broken the Supreme Court to the degree that he has. Now that we don't have the requirement that you need 60 votes in the Senate to confirm a Supreme Court justice, the need to nominate more moderate. They don't have to be, they don't have to be bland super moderates to be able to get support from both sides, as long as people know that the senators know that they're going to have a shot at some point, and there's going to be favors to return. So, you voted for my guy, I'll vote for your woman. But that's not necessary anymore. And we know what happened with the Merrick Garland nomination, that got sat on. And, I think a lot of us have feelings about Merrick Garland now that might be a little different than we felt back when his nomination was not being voted on. But, they ran out the clock and waited until Trump was in there to make the appointment. And he's gotten a couple more seats since then. And if they didn't need just 51 votes, or even, you get a 50-50 split and you have JD Vance there to cast the tie-breaking vote, you can choose ultra conservative, right-wing very, some of them with extreme religious views, some who have said bizarre things like racial profiling is okay when we're rounding up, when ICE is rounding up people. It's okay to look at the color of someone's skin and assume that they might be an illegal. so nothing wrong with grabbing all those folks up. It's a court that's really out of control, and it would be in the other direction as well. We shouldn't have a court that is way left leaning.
Right.
That's the country should not be doing these wild pendulum swings with Supreme Court rulings.
I think it's, we're in this moment where increasingly we are a minority ruled country. The idea that if you think about,
and you mean a minority of people, not
sorry,
people who are
not ruled by the majority, ruled by the minority of people. I mean, in 2016, Donald Trump lost the popular vote. He has never won a majority of the electorate. Let's say that again. He has never won a majority of the electorate. Right. And yet he is going to be able, by appointing loyalists and partisans, to control the court and really control the government, because the court is so willing to intervene on his behalf vis-a-vis Congress, vis-a-vis civil society, right, with the shadow docket and elsewise. Yep. That doesn't make any sense, right? And so you end up in a world where, well, just because, I don't know, people get sometimes like the justice is really old, Justice Ginsburg, she couldn't quite hold on, right? And then you get, right? So you get this weird vicissitudes of like, do old people die or do they not die? Like whatever, like that determines the ruling of the country. It doesn't make any sense. And a court is fundamentally, it depends on legitimacy. It depends on people believing that even if they don't agree with the decision, that it represents a sort of good faith determination of the law in a way that the political branches of government don't. Right? Politics, I can think the other guy's a piece of crap, and I can hate what he has to say, and I can believe he's corrupt. And 2 years from now, or 4 years from now, or 6 years from now, I can vote for somebody else and I can replace him. Right? But an unelected Supreme Court that has no direct political accountability to me. Either I believe that it is, calling balls and strikes and doing, even if dumb, a kind of good faith attempt to apply the law, or I believe it's fundamentally illegitimate, and I believe our government is illegitimate as a result of it, right? And the difference between those things, it seems to me, is night and day. And we are firmly in the latter category right now, and it is it's in everybody's interest to try to fix that thing. Whether we'll do it or not is a separate question, and I fear greatly that the next person is going to want to, whether it's a Republican or a Democrat, want to kind of move on and not focus on the past and all of that. I think that would be a great
return
mistake.
To regular decorum and
I think that was Joe Biden's mistake. It was just we just want to back to Mitch, old buddy, it's Joe, right, different world. That world is gone. It is as gone as landlines and rabbit ears on TVs and white wall tires. It's gone, and we need to kind of reckon with what we've learned about our government, about human nature, about technology, and build systems that are robust. And I really I think there are some folks in politics who understand that. I don't think there are many though, and I hope that's who we have lead us.
Yeah, I hope so too. As we're looking forward to the midterm elections, there was a withdrawal of one of the two Democratic candidates in Maine today, which has now set up election in November that's going to be between Susan Collins and Graham Plattner. And look, I'm not gonna say Graham Plattner is my favorite dude on the planet by any stretch, but this is going to be interesting, and control of the Senate is it's more up for grabs than it was 6 months ago. As long as we have free and fair elections, I always feel like I have to now stick in that little caveat that we're still going to do that.
Let's hope Graham Plattner doesn't turn out to be another John Fetterman. But I am somewhat hopeful. But that was sometimes these weird candidates that come out of left field have a little bit of risk associated with them. So
yeah.
Anyway,
So we'll see how that turns out. And we will be back here with all of you next Wednesday. Thank you so much for joining us. Please do all the things to spread the word about the podcast. And great talking with you, John.
Yeah, you too. Thanks for the chat. We'll see you next week.